on this, our final day of argument. In light of the current situation, we are conducting this session remotely. The court felt it best to proceed in this manner rather than canceling or postponing the session because we consider it vital that courts continue to function, even in these relatively difficult times. Traditionally, our court does not impose time limits on counsel, but due to the unique circumstances, we have developed a special protocol which has been forwarded to all counsel who will be presenting argument. Generally speaking, counsel for appellant and appellee will have a maximum of 20 minutes with the first several minutes reserved for an opening statement and the final 2 minutes for closing remarks. We would ask counsel to keep an eye on their watches, but we'll be certain to alert them as we approach the conclusion of the argument so that they can summarize and promptly conclude. Justices who have questions will pose them in a preset order so the counsel might focus their attention on the justice asking the question. Finally, as is custom, I will first briefly state the case in order to frame the issue before the court. Mr. Minner, would you please call the first case?
First argument is in the matter of Commonwealth of Pennsylvania versus Chesapeake Energy and Anadarko Petroleum. Representing Anadarko Petroleum is Stephen A. Cozen. Representing Chesapeake Energy is Daniel T. Breyer. Representing the Commonwealth is Howard Hopsack.
Good morning. Mr. Cozen, Mr. Breyer, you've requested and been granted an additional 10 minutes to present your case. Since there are two appellants, I understand you'll be dividing your 30 minutes equally. Start with Mr. Cozen. In terms of the issue before the court, appellants are energy companies that executed leases with Pennsylvania residents for natural gas extraction. The Attorney General filed a lawsuit against appellants pursuant to the Unfair Trade Practices and Consumer Protection Law, alleging that they used deceptive, misleading, unfair tactics in securing the leases and also acted in restraint of trade. Appellants are challenging the applicability of consumer protection law to them, given their status as lessees. Appellants also argue that antitrust claims are unavailable under the statute. Mr. Cozen.
Thank you, Your Honor. If the court please, Steve Cozen for Anadarko. It is the overreach of the Attorney General and the faulty reasoning of the Commonwealth Court which brings us here today. This court granted aliquotter for the purpose of determining whether the Attorney General had the right under the CPL to exercise enforcement powers against buyers rather than sellers, to utilize the CPL as an antitrust law, and to exercise such enforcement powers over commercial transactions generally. The rules of statutory construction, the text of the Act, and the legislative history say no. But the Commonwealth Court analysis is simple and wrong. 1, all leases are sales. 2, these sales fit in the second phrase of the definition of trade and commerce, where the words "and includes" is a catch-all of sellers and buyers under a dictionary definition. And 3, with the rabbit now in the hat, they hold anyone connected with such transaction may be sued by the Attorney General under the CPL. Since its enactment in 1968, no Pennsylvania court until now has ever interpreted the CPL as authorizing a claim by or on behalf of a seller against a person who acquires something from a seller, or as separately authorizing a right of action against a person simply because that person is involved in any form of commercial transaction. Earlier in this case, the AG conceded that Anadarko was a buyer and that the landowners were sellers in these transactions. The text of the CPL and the definition of trade and commerce contains neither textually nor grammatically the suggestion that trade and commerce has two separate meanings, and that the second means this section applies to business transactions generally. Anadarko is not advertising, is not servicing, is not offering any service or property, is not selling a service or property, and is not distributing a service or property. The bottom line, Anadarko is not engaged in trade and commerce as defined by the CPL, and its terms are inapplicable to the transactions in question. The entry into oil and gas leases by Anadarko are transactions not covered by the CPL because Anadarko as buyer is simply entering into a fee simple determinable or a defeasible grant of all the oil and gas in and under the described premises with rights of ingress and egress for the purposes of drilling and operating oil and gas wells in return for future royalties if they do so. The first question then,
Mr. Cozen, with that opening, which we've allowed, I would like to ask the justices if you have any questions, so you have an opportunity to interface with the court. And we'd first ask Justice Fair.
Thank you, Chief Justice. Mr. Cozen, I think you have indeed put your hand on the pulse of the case. Given in our complex society, there are many buyers that in fact control the transaction. Major meat packing facilities, dairy farmers, perhaps Jolly Green Giant in vegetables. I thought about the fair trade coffee movement because of the exploitation of coffee growers, although certainly not in the United States. But given the reality that purchasers control transactions in the same way that the legislature sought to cabin sellers, why doesn't it fall that within legislative intent that last clause of 20123, which says, and includes any trade, the word any, I think, is more dispositive than and, or commerce, directly or indirectly affecting people of the Commonwealth? Why isn't that a reasonable construction?
No, it says engaging in any other fraudulent or deceptive conduct, which means as we outlined in the prior 20. But I think the answer to your question, Justice Fair, with due respect, is that this is really not an issue for the courts. This is an issue for the legislature. The legislature is to determine whether or not certain transactions and certain relationships ought to or not to be part of the or encompassed by the consumer protection law. In this case, I go by the text and the statutory construction of the text, and there is no indication anywhere in here that these parties are anything other than seller and buyer. This kind of a transaction is well documented as landowners or sellers. That's DeFazio.
Mr. Cozen, may I interrupt you because my time is limited, and I'm not sure that you put your finger on what I wanted to hear from you. The language I'm looking at, and I trust it's accurate, is 20123, definition of trade and commerce, and it's the clause, and includes any trade or commerce directly or indirectly affecting the people of this Commonwealth.
Yes.
Do you understand what I'm asking? And my question is, why doesn't that include sellers, to make this easy? I'm sorry, buyers. Why doesn't this include buyers?
It doesn't include buyers because that definition of trade and commerce is unitary. It is not separated into two different sets of ideas or phrases. Trade and commerce and includes any trade or commerce means, like what we just said in the prior language, advertising, offering for sale, sale or distribution of services, and any property. And directly or indirectly affecting the people of the Commonwealth is a description, as Chief Justice Saylor, I think, recognized in the most recent decision that he wrote in Dangannon, really is defining the protected class. So when we say and includes trade or commerce, it means trade or commerce as heretofore defined in this sentence, which affects directly or indirectly the people of this Commonwealth. So it's one unitary definition. In fact, the rules of statutory construction dictate that result, because under 1921A and 1921B, they refer to being governed solely by the text and not expanding the text beyond that which the legislature deemed appropriate to provide. I hope that answers your question, Justice.
It does, and I appreciate it. Chief, thank you for the time.
Thank you, Justice Todd.
Thank you, Chief Justice. Mr. Cozen, Justice Baer covered my question that I had about the interrelationship between the two provisions, and I think you've answered that very well. I just had one additional question, and it's about your characterization in your brief that our court has never construed the UTCPL in the fashion that appellees and the majority of the Commonwealth Court construed it. And I'm asking, that may be true, I believe that is true, but we've never construed it otherwise, have we? We've never had a case on point with these circumstances to address, have we?
No, not really. I think that this is a case of first impression. And I think it can go back to monumental property, and you can go back to also the Chief Justice's opinion, in which everybody concurred in more recently. But those cases clearly stated that their basic premise and predicate was that the CPL, and I'm just using that as shorthand, that the CPL was a consumer protection law. Now, we could always argue about whether or not Justice Roberts should have or should not have decided the rental property question, and whether lessees of rental property were in the same position as consumers and the lessors of rental property were in the same position as sellers. And I think the answer is he got it right, where it me, as a strict constructionist, I would have said the court shouldn't have taken that case. They should have left it to the legislature. But I have no argument with the analysis. But I do want to point out one thing, and this is important. Had Justice Roberts, before whom, and with all respect, before whom I appeared several times, had Justice Roberts adopted the interpretation of the Commonwealth Court as to what the "and includes" language means, he would have never had to go through all of the painstaking analysis that he went through in order to determine who was a seller and who was a consumer, because under their interpretation, the language "and includes" and thereafter makes meaningless everything that you said before in this definition. It makes it superfluous. So why go through this really painstaking analysis that he went through to justify his holding? It gives monumental properties, does two things. It says consumer transactions, and it gives the big lie to the Commonwealth Court's decision and the Attorney General's argument that the words "and includes" is a totally separate and distinct definition that brings all kinds of commercial transactions under the aegis of the Attorney General. And were that not bad enough, when you ultimately get to the antitrust question, can you just imagine that it was the intention of the legislature under 201-4 to give district attorneys around the state, for every county, the right to enforce antitrust laws? It makes no sense, and there's no indication. Thank you, Justice.
Thank you. Justice Donahue.
Thank you, Chief. Good morning.
Good morning, Justice Donahue.
I want to follow up maybe in the same thought process that Justice Baer had. I'm thinking of the terms buyer and seller in the context of this transaction and the economic reality that's at play here. And so I'm just wondering if indeed we need to shoehorn this transaction into the concept of buyer and seller, why it isn't in keeping with the economic reality here that gas extractors are actually selling their services as gas extractors to individuals who are, looking for the ability to have their gas extracted. Assuming, for the sake of discussion, that we are indeed dealing with an open market in all of these territories, where owners of gas rights can actually look for the best deal and then decide who they want to choose to extract the gas. Why isn't it that companies like yours that you're representing shouldn't be viewed as sellers of gas extracting services, which fits squarely within the context of the statutes as you would be interpreting it?
Three answers. One, the language of the statute and the legislative history beyond the language of the statute does not give support to that kind of an analysis. Number two.
Why is that? Before you move on, why is it? I mean, if what we're looking at is buyers and sellers, why aren't your clients sellers of extraction services?
Because that's not the nature of the structure of the deal, number one, and number two, because this is not a consumer transaction. And number three, if you look at the cases that deal with CPLs around the country, they will all say that a oil and gas lease is the sale of a determinable fee simple interest. And if you look at the contracts, Justice Todd and I had a case called Shedden, where she wrote the opinion, had to do with estoppel by deed in the oil and gas context. But the contract made it clear that nothing was being sold. There was a purchase of rights. Now, if you follow your question to its logical extreme, then what you have is you're telling me that if I'm involved in a business transaction where my client is selling its business to Mr. B, and Mr. B wants to pay consideration of cash and a share of future profits, that Mr. B is actually selling the future profits to my client, and the Attorney General can interfere with our private party transaction in the sale of a business. I think that's absurd, quite frankly. I see absolutely no support for that, either in the language itself or in the legislative history.
Thank you, Mr. Kozin. With that, we're going to turn to Attorney Breyer.
Thank you. Good morning, Chief Justice. I'm Dan Breyer, and I represent Chesapeake. This is a test case. Test is whether the consumer protection law is so expansive that it can be invoked by the Commonwealth to seek antitrust remedies and to seek relief on behalf of sellers, not consumers. In a 300 paragraph complaint, the word consumer appears once, and that is in the name of the statute. For over 50 years, this court and every other court in the Commonwealth that has looked at the statute and has interpreted it has concluded that its object and its purpose is to protect consumers. From 1974 in Monumental Properties to the recent decision in Golden Gate, this court has stated that the purpose of the statute is to even the bargaining power between consumers and sellers so that they are on equal footing. This is not academic. If sell also means buy, then the statute will become a general, all-purpose business regulation statute that can be invoked by any district attorney or the attorney general. This case is controlled by the plain text of the statute. In every respect, the statute supports only one conclusion, and that is that its object was to protect consumers. The Attorney General's counter-argument is based on a misreading and candidly an absurd reading of the definition of trade and commerce, and also an overreading of this court's decision in Dangannon. On the antitrust question briefly, the Consumer Protection Law protects consumers, not markets. Nowhere in the statute does it even reference antitrust concepts such as restraint of trade, monopolies, price fixing, joint ventures, or any other concept. It is also critical to note that the statute does not expressly incorporate any antitrust statute, and that distinguishes it from the Federal Trade Commission Act that expressly incorporates the Sherman Act. When the Independent Review Commission looked at the Attorney General's rulemaking and his attempt to define sale to include buy, and his attempt to add 10 new market practices that would be prohibited under the Act, the Independent Review Commission said that the Attorney General was exceeding his authority. In short, the General Assembly's intent was and is clear. The statute protects consumers, and liberal construction does not change that fundamental object of the statute. I look forward to your questions. Thank you.
Thank you, Mr. Breyer. Justice Doherty.
I would like to follow up just as what Justice Monday said. Why could not the conduct of your client be construed as selling oil and gas extraction services? I find that to be the pivotal question here.
Thank you, Justice Doherty. The reason for that is several-fold. First, when the transaction occurs, the appellants are not under any obligation to develop the property. When the lease is signed, the fund flow goes from the appellant to the seller, and they are paid an upfront royalty. That gives the appellants the opportunity, but not the obligation, to develop the mineral rights. And if they don't develop the mineral rights revert back to the seller. So it is not a contract for the sale of distribution services, gas distribution services, because we're under no obligation to develop the gas. The only thing that happens when the lease is signed is a upfront payment is made, and that upfront payment is for the potential to develop the gas. And many, many, many leases are not developed. I hope that answers your question, sir.
So that's analogous to a pawn shop then, correct?
In what way?
Where the customer would be the store owner and the seller would be traditionally regarded as the customer.
If I'm following your example, sir, the store owner who has the opportunity to purchase something from the person coming in seeking to get value for it is, the store owner is a purchaser in that instance. And the seller is under no obligation to confer the article for any value. If it doesn't like the value that the store owner is offering, the seller is under no obligation to enter into a transaction, just like the landowners here. They were under no obligation to engage in a transaction with the appellants.
Fair enough.
Thank you. Justice Wecht.
Thank you, Chief Justice. Good morning, counsel.
Morning.
Mr. Breyer, you point out, and you and Mr. Kozin both point out, that the General Assembly did not pass the antitrust statute. Does that exclude the possibility that the CPL could allow for claims sounding in anti-competitive behavior relating to consumer confusion? In other words, not the tie-up arrangements, not antitrust writ large, but some types of anti-competitive behavior. Does your argument reach so far as to say that under no circumstances can the statute reach those?
It does, Your Honor, because the Consumer Protection Statute and the General Assembly's intent in enacting it was not to reach any conduct that would affect competition or markets. The statute is bereft of any standard that a trial court would apply in the future to decide whether the alleged conduct was in fact actionable under one of the 21 subclauses of this statute. So, for example, in this case, there's an alleged joint venture between the appellants, and it's noteworthy that that's the only issue that's not before the court, and that is the Commonwealth Court found that the joint venture is not per se unlawful. So here, what you would have is a remaining count in count 4 that seeks to make actionable the failure to disclose a joint venture that was not in fact unlawful. So the answer to your question is yes, this is not a antitrust statute, and if the General Assembly wants to enact an antitrust statute, it has that opportunity. It's 26 times it's considered it and decided not to. And the Attorney General cannot convert this consumer protection statute into a general business antitrust statute.
Thank you.
Justice Mundy.
I have no questions at this time. Thank you.
Thank you. How much time do you have? Okay, we still have some time remaining. So, Justice Baer, do you have any questions of Mr. Breyer?
You're on, Justice Baer, you're on mute.
Can you hear me?
Yes.
I apologize. I was told my paper rattling was distracting. So thank you, Justice Donahue. Mr. Breyer, in making your opening presentation, did I discern an attempt to distinguish between a seller and a consumer under this statute?
Yes, sir.
You want to elaborate on that?
Yeah, consumers are purchasers. Consumers are persons who are engaged in a transaction where they're conveying value to a seller. The sellers are not consumers.
I understand. I misunderstood before. Let me ask you a different question in my scant time. Again, in your opening, you discussed the underlying legislative intent was to equalize the balance of power between a seller and a consumer. And we discussed this a little bit with Mr. Cozen. In the real world, where buyers such as your client really hold all the economic sway as opposed to the small owners, particularly given your joint venture, which was, regardless of whether it was actionable or not, was anti-competitive. Doesn't it make sense that the legislative intent, as we read the statute, would be to give some protection to those sellers who are indeed the tread upon party in these transactions?
Respectfully, Justice Baer, it doesn't. And I want to point out something that's very important. In the second amended complaint, and this is in the reproduced record at pages 1009 and 1010, the Attorney General, in fact, alleges that many landowners negotiated, quote unquote, hard bargains, and that the appellants revised lease terms based on insisting demands of the landowners. And in fact, the reality is the landowners consist of all kinds of people. There are very significant corporate entities that own significant amounts of land. Landowner groups that got together and formed groups and hired lawyers. So the narrative that has evolved, that this is some relationship that is disparate, is not supported by the Second Amendment complaint, which proves or which alleges that the landowners, in fact, demanded and insisted on terms, and the reality in the market. And secondly, it's not supported because that's a decision for the General Assembly, sir. The General Assembly's definition of trade and commerce is focused on conduct that sellers engage in. If it wanted to write a statute that protected the party that didn't have as much bargaining power, it could have written it very differently to say trade and commerce means any transaction involving a transfer of money. And then we'd be looking at, in every instance, who had the bargaining power, who had the leverage. So it's not supported by the Second Amendment complaint, and it's not supported by plain terms of trade and commerce.
Thank you.
Thank you, Justice Todd.
Yes, thank you, Chief Justice. Mr. Breyer, in follow-up to a line of questioning that Justice Donoghue pursued and Justice Baer followed up on as well, in order for us, in construing this statute, to give regard to the economic reality, what's really going on out there in some's view, don't we need to go beyond the plain language of the statute and delve into the spirit of it?
Your Honor, there's much case law that says that the court should not ignore the plain text of a statute to pursue its spirit. This statute is clear. It is intended to protect consumers. The fact that this is a case of first impression involving gas leases doesn't change that the fundamental object of the statute is to protect consumers, and that the Commonwealth has said on the record and has never wavered from this. This is at page 2759 of the record, that the landowners are sellers. They are not purchasers. So I don't think you can go beyond the plain text of the statute that controls. I want to make one other brief point. These landowners are not without relief. There is a class action settlement pending before Judge Mannion in the Middle District, brought by very able plaintiffs' counsel, that was preliminary approved by the trial court. So they know how to get relief, and they have sued in contract, saying that our clients, the appellants, did not honor the contracts. So if this court reverses, as I urge you to do, the landowners are not without relief. There is before the court a preliminarily approved settlement.
Thank you, counsel.
Mr. Breyer, we're at the 2-minute mark. If you would like to say a word or two by way of summation, we'll then turn to the Commonwealth Aplt.
Thank you, Chief Justice Saylor. In closing, I want to thank the court for facilitating this video argument. It's a critically important issue to everybody. The second question involving antitrust is controlled by the first question, if this court agrees with me that the statute is not intended to and does not protect sellers. The issue is very simple. The Attorney General only has the authority granted to him by the General Assembly. He has no general police power authority. He has no penumbra of rights to pursue what he believes to be actionable at law. He must act in accord with the statute, and he can only pursue claims that occur in trade and commerce, and these don't. The the trial court, Judge Brown, was very skeptical of the Attorney General's effort to bring this case under the Consumer Protection Statute. He should have trusted his skepticism. Judge Covey, in I think a brilliant dissent, got it right. I respectfully ask this court to reverse the Commonwealth Court and to remand the matter to direct that the preliminary objections be sustained. Again, thank you for your time. I very much appreciate it.
Thank you, Mr. Breyer. Thank you, Mr. Cousin. We'll now hear from Mr. Hopkirk.
May it please the court. My name is Howard Hopkirk. I am a senior deputy attorney general. I represent the Commonwealth. The Commonwealth maintains that Chesapeake and Anadarko have violated the unfair trade practices and consumer protection law in two ways. First, they have acted deceptively by inducing landowners to enter into oil and gas leases, but then reduce the amount of royalties promised based on misrepresented post-production costs. Second, they have acted unfairly by entering a market allocation agreement through which they diminished competition and thereby lowered the market rate for bonus payments and royalty rates. Chesapeake and Anadarko's defense today is not that they didn't engage in the activities. Instead, they argue that they cannot be liable under the law because they are not engaged in trade and commerce and are not sellers of goods or services. Despite their protests, there is no real doubt that securing leases for the production of natural gas is a business activity which constitutes trade and commerce. Section 2 of the law defines trade and commerce broadly. Restricting its scope would diminish the rights of Pennsylvanians in a manner which is contrary to the General Assembly's intent in enacting the law. Chesapeake and Anadarko's argument largely rests on their position that only sellers of goods and services may be liable under the law. However, this is simply not true. Sections 7 and 9.2 provide for private actions against sellers. They do not impose general limitations on the definition of trade and commerce for other parts of the law. This is a public action brought by the Attorney General under Section 4. Actions under Section 4 are not limited to sellers and may be brought against any person engaged in unfair and deceptive trade practices. As for the second issue, Chesapeake and Anadarko maintain that anti-competitive behavior prohibited by federal and state antitrust law cannot be the basis of a separate cause of action under the law. However, the court should look to whether there is a violation of the law, not whether such violation would also constitute an antitrust violation. It is the Commonwealth's position that actions which constitute separate violations of antitrust law are also encompassed by and may provide for a cause of action under the Unfair Trade Practices and Consumer Protection Law. For these reasons, the decision of the Commonwealth Court should be affirmed.
Thank you. Justice Donahue.
Thank you, Chief. Counsel, I'm going to follow up on my earlier question regarding the economic reality of this transaction, and I'm looking for a reprieve from someone that it isn't an absurd analysis. So let me ask you, why has the Attorney General not taken the position that the economic reality of this transaction is that the gas extractors are selling their services as gas extractors?
So that is a theory which we have thought of, but our position is if you look at the meaning of trade and commerce, the definition.
I understand that, Counsel, and if your answer is that you're trying to get the broadest possible interpretation from this court as to the scope of this act, then to me that's not a legitimate response. Assume, just for the sake of discussion, that we conclude that the parameters of this act are set forth fairly clearly in terms of their protection for consumers and the dichotomy between buyers and sellers. In that context, should we look to the economic reality of a transaction to determine whether or not here, for example, there is in fact a sale of services that is taking place by the gas extractors?
I think the transaction could be viewed that way. I would push back a little bit that this action is brought under Section 4 in the public interest by the Attorney General, which is broader than Section 9.2, where it specifically talks about sellers.
Okay, thank you.
Thank you. Justice Doherty.
Justice Doherty, you're on mute.
Yeah, now, thank you. Counsel, I have a question. Why is it after a failed attempt at least 24 times by the General Assembly to pass an antitrust statute, should we permit you to do what the General Assembly has not intended pursuant statutory interpretation by permitting you to craft a claim under the unfair trade practice?
So our position is that the law covers unfair and deceptive practices, which may or may not also fall antitrust context. You could also postulate that the General Assembly saw the broad reach of the consumer protection law and said, we don't need an additional antitrust statute this behavior is largely covered by the consumer protection law anyway. I think that's as reasonable an interpretation of the legislature's actions, and I don't think you can say just because the legislature did not pass an antitrust law that somehow limits the scope of the consumer protection law.
So joint ventures in business, it appears that your attack on this matter is the two businesses operating together. What's wrong with that?
What's wrong is that the landowners were not informed that the two companies were dividing up the territory and therefore artificially lowering the price which landowners could get for leases for oil and gas production.
Is that any more deceptive than businesses having subsidiaries and where one money is going through the pipeline to other businesses?
I'm sorry, I couldn't hear the last part of your question.
The question I have is, so in the form of business, a subsidiary of a business you do business with, and somehow the money is being shared between different individuals without your knowledge or as a consumer, is that also deceptive?
I guess it would depend on the facts. In this case, we're dealing with the second amended complaint where the Commonwealth has alleged that the tactics were deceptive. It's not a question before the court whether that's true or not.
And what was deceptive? What are you sharing? That they were in a joint venture without sharing with their landowner?
Yes, that's largely it.
And again, I ask you, what was deceptive about that? Just the fact that they didn't say that they were in a joint venture?
Well, they didn't disclose that the landowners might have been able to get a higher price and there was actually more competition for what they were selling.
Would that be incumbent upon the landowner to inquire as to the various? We know that there are more than two businesses extracting Marcellus shale.
So it's our position that it violates the consumer protection law, that it's a deceptive trade practice.
Your underlying premise is that the landowner is ignorant as to what they're doing with their land?
Well, they would be ignorant no matter how sophisticated they are regarding the contractual relationships between Chesapeake and Anadarko.
Well, if you're saying a contractual relationship, why wouldn't the remedy be a breach of contract as opposed to unfair trade practice or antitrust?
The Commonwealth believed that this was a widespread practice affecting the public, and so the Commonwealth's remedy was through the consumer protection law. That does not.
And then finally, how many landowners were affected when you called this widespread?
It's in the complaint. I don't remember.
Hundreds?
Maybe 100. I can't tell you that.
Fair enough. Thank you.
Justice Wecht.
Thank you, Chief Justice. Good morning, Mr. Hopkirk. Would you agree with me that the General Assembly has the power to give trade and commerce whatever definition it chooses, and in fact, for example, to exclude buyers as it does here? Or is it your position that Noah Webster gets to call it?
It has the power. I didn't hear the last part of that second question.
Well, we don't go to Noah Webster if the General Assembly defined it, right? You agree with me?
Yes, Your Honor.
All right. Well, I'm interested in your view of the interaction of the two clauses. Would we read this definition of trade and commerce to say that the General Assembly wants us to give a different definition of trade and commerce when it affects Pennsylvanians and when it doesn't?
I think it's a general enlargement of the meaning of the first clause. And I think in Dangannon, the fact that the plaintiff was an out-of-state resident not pertinent to how you apply statutory construction to the second clause.
Does that mean, Mr. Hopkirk, that does that mean that it's a tail wag the dog situation where the second clause is the General Assembly telling us, oh, never mind, disregard our first clause, it's just everything?
Well, I don't know that it's everything, but it's certainly, if it doesn't mean anything, then why did the legislature do it? Put that language in also. I would also double back and say our initial position is that the first clause covers this, that you're talking about a sale, which is trade and commerce. And so that's a specific activity. And whether someone's a seller or a buyer does not matter once you say this is trade and commerce.
So is your position then that the statute is ambiguous or not ambiguous?
Well, I think the second clause has some ambiguity, but then given the court's traditional liberal interpretation of the act, that clause should be interpreted.
But would you agree that you could make your case to the General Assembly rather than to us?
Well, we certainly could make our case. We don't think we need to because we think this activity qualifies under the existing language.
Last question, and it's a follow-up to something opposing counsel mentioned earlier. If you prevail here, what's to stop district attorneys around the Commonwealth from wielding this statute as a sword in any business transaction where that they're not fond of?
Well, if it's just an ordinary breach of contract situation, that doesn't necessarily make it an unfair and deceptive trade practice. If you contract to produce 1,000 widgets for somebody and you fall short, that doesn't mean that you were deceptive in what you did. And the ordinary thing would be to bring a breach of contract action to, gain what you lost, if that makes any sense.
Thank you, Mr. Hopkirk. Justice Mundy?
I have no questions right now. Thank you.
Okay, well, Mr. Hopkirk, you've ably presented the Commonwealth position and responded to questions that you can tell the court, as typically is the case, is well aware of the discrete issues. So if you had a word or two by way of summation, we'd appreciate that.
Okay, thank you, Your Honor. The Unfair Trade Practices and Consumer Protection Law was enacted by the legislature to protect the citizens of Pennsylvania from unfair and deceptive practices in the marketplace. Chesapeake and Anadarko, through this lawsuit, would limit the scope of the law so that it would serve only as a consumer protection law with limited authority against sellers and exempt other conduct completely, which constitutes an unfair and deceptive trade practice. Chesapeake and Anadarko would largely negate the authority of the Attorney General to bring actions in the public interest to prevent businesses from engaging in unfair and deceptive trade practices. Their position is contrary to not only the statutory language of the law, but the liberal interpretation which has been given the law by this court for the past 50 years. Chesapeake and Anadarko's conduct as alleged in this case constitutes unfair and deceptive conduct for the purposes of the law.
Thank you. Thanks to both counsel. With that, we'll conclude the argument in this case and call the case in 5 minutes. Thank you.
The next argument is in the matter of Nancy K. Raynor versus Matthew D'Annunzio and Messa and Associates. Representing Messa and Associates is Robert S. Tintner. Representing D'Annunzio is H. Robert Fiba. Representing the appellee, Nancy Raynor, is Clifford Haynes.
Good morning. The Dragonetti Act permits the recovery of damages, including expenses, attorney's fees, and punitive damages where a person wrongfully takes part in the procurement, initiation, or continuation of civil proceedings against another. The court allowed this appeal to address whether the act applies in relation to an unsuccessful motion for contempt and sanctions against opposing counsel in the context of a pending medical malpractice action. Mr. Tintner.
Yes, Your Honor. May it please the court, my name is Robert Tintner, and I, along with my colleague Abraham Rich and our co-counsel Kathleen Rebar and Patrick Healy, have the honor and privilege of representing Joseph Messa and Messa and Associates. We are splitting our time per court order. Mr. Feedback, who represents the other appellants, will be addressing the issue of standing, which is the court's second question. In reversing the trial court on the wrongful use of civil proceedings claim, the Superior Court of Pennsylvania, in essence, expanded the potential scope of liability under the Dragonetti Act. And it is an outlier decision. It's a decision that's inconsistent with other Pennsylvania cases that have looked at the issue. And for three reasons, we believe this honorable court should reverse that part of the Superior Court order dealing with the wrongful use of civil proceedings. The first reason is that a motion, and this was a motion for sanctions and for contempt contained within a post-trial motion, does not constitute civil proceedings as defined under the Act. And as our cases, Pennsylvania cases, appellate decisions have looked at the issue, which have looked at civil proceedings in that context as a lawsuit. If you look at the trial court's decision in which it looked at the definition and looked at the other cases that have addressed this issue, it was directly on point. Every other case that's looked at this, whether it was preliminary objections, a new matter, service of a subpoena, the court has said, no, that does not constitute civil proceedings. And to rule otherwise would be inconsistent with how Pennsylvania has defined it and what the correct definition of a civil proceeding should be. The second reason is the original enactment of the Act contained a provision, 42 PACSA 8355, that dealt with motions, pleadings, and other papers filed. When this honorable court enacted Rule 1023, and in essence repealed that part of the Act. And the point is, if in fact it repealed it, and we should be governed by 1023, that's the appropriate mechanism by which we should look at potential motions for sanctions or the denial of a motion for sanctions. Rule 1023 has a mechanism where you can cross-move. It's not that Ms. Raynor here did not have a remedy. She chose the wrong remedy. And the third reason is that this is a public policy issue. Do we want trial courts and their authority to govern issues like sanctions, contempt? Do we want them second-guessed in the middle of the case when it ultimately may not be a prevailing party? Do we want a floodgate of Dragonetti Act cases based on individual motions, pleadings, things that should be properly and appropriately governed by 1023? And for that reason, we respectfully request that this honorable court reverse the Superior Court order with respect to the wrongful use of civil proceedings.
Thank you. We'll begin the questioning with Justice Todd.
Thank you, Chief Justice. I have no questions at this time.
Thank you. Justice Donahue?
Good morning.
Good morning.
I'm a little bit, first of all, the Superior Court's decision by Judge Kate Ford Elliott was very circumscribed in its reach. It really came to the conclusion that what happened here was akin to, on par with, a civil action. And I'm just wondering, from a statutory basis, where do you get the notion that civil proceeding only means civil action, where the statute does not use that phrase? And then secondly, this is indistinguishable from my perspective from a civil action, not only because of the hearing, the award, but the fact that there was actually an execution action on this award, a garnishment of bank accounts, a lien on the home. And so I'm just, from a practical perspective, having a hard time grappling with the notion that this is not indeed a civil proceeding.
Well, it's part of a civil proceeding. No one would dispute that it's not part of a civil proceeding, but it's not a civil proceeding in its entirety where it was a plaintiff who commenced an action against a defendant, and ultimately one of the parties prevailed at the conclusion of the case and was able to bring a wrongful use of civil proceedings claim under the Dragonetti Act.
But
we
see,
recognize that
your answer sort of puts the bunny in the hat. I mean, because if you want to use your analysis, Attorney Raynor would be the plaintiff in the Dragonetti Act. She was a defendant in the contempt proceeding, and so I mean, if you look to what the apparent reason for the Dragonetti Act was to prevent or discourage proceedings that had no basis in the law or fact, and I express no judgment on that aspect of it. I'm having a hard time understanding why this doesn't fall within that realm.
Because in fact, it was an individual request for sanctions and contempt as part of a post-trial motion. It only got separated out and was considered because the trial court wanted to allow the appeal from the trial court's decision on the denial or the grant of the new trial to proceed. Otherwise, it would not have taken on what you're describing as this separate process. There's no question that the trial court handled it in that manner. But that in and of itself does not make it a separate civil proceeding with a plaintiff and defendant. In fact, Ms. Raynor, along with her clients, were actually, and the person who was the witness, who was subject to the in limine order, were all respondents in that proceeding. And that they were not separate defendants. They were not sued. They were respondents, and they were part and parcel to the claims itself. They were not separate claims. And I would say to Your Honor, it's no different. And there are Superior Court decisions, one by Justice Monday, that says that, in fact, if you win on a particular claim, that doesn't give you Dragonetti Act liability. You have to win in the entire case. And that is how it's been interpreted. And I understand what the Superior Court said, and a motion for sanctions, while different, no question, motions for sanctions are governed by two statutes, 42 PACSA 2503, and the rule that this court enacted, Rule 1023. That is the mechanism by which you seek sanctions, and you can, in fact, counter request sanctions if, in fact, you believe that the motion for sanctions was brought in properly. It's intra-litigation. It's within the case itself, not a separate proceeding.
Thank you.
Thank you, Justice Doherty.
I have no questions at this time.
Justice Wecht.
Thank you, Chief Justice. Good morning, Counsel. Does our precedent demand a per se rule for interpreting or a per se definition of civil proceeding, or is there something to be said for the I guess walks like a duck, quacks like a duck approach of Superior Court?
Well, I think the concern with the Superior Court, and I understand that walks like a duck, talks like a duck. I just think that they came out on the wrong end of the way the only cases that have looked at the issue have decided it. This is not the first time that a part of a case has been looked at. And that's the point, is that preliminary objections, a reply to new matter, recently, a subpoena. We understand that can take on a part and parcel of a civil proceeding, but the way the courts have always interpreted it is it's the entirety of the case. So perhaps we do need a definition from this court to clarify this point so that we don't open the floodgates for actions of Dragonetti based on motions. They should be following 1023.
What about counterclaim, cross-claim? that sort of thing, interpleaders. I just trying to test the limits of your definition.
Absolutely. Well, a counterclaim is certainly different because a counterclaim can be brought separately. A counterclaim can have the effect of a separate action. But the reality in a counterclaim is if you prevail, you have to prevail on both, right? You have to prevail on the claim in chief and you have to prevail potentially on the counterclaim. And what may end up happening, and I have litigated cases where the case in chief is gone and you're only litigating the counterclaim. So the defendant becomes the plaintiff and the plaintiff, the prior plaintiff becomes the defendant and reverse. And so a counterclaim is a separate cause of action. It can be initiated. A counterclaim can obviously take the place of a cause of action and can be brought separately. It doesn't have to be brought part and parcel with the case.
If I may, just one more thing along that line.
Yes.
What would you suggest to us by way of interpreting the curious section 102 of Title 42? And I refer specifically to the definition the General Assembly gave us there of proceeding, ending with the words, but the term does, and I quote, but the term does not include an action or an appeal.
I don't know that I can necessarily interpret that, but what I can say about a motion is nobody here is telling you that a motion is not part of a proceeding. Okay, it is part of a proceeding. But is it what the Dragonetti Act intended by civil proceedings terminating in their favor? And I would just point out that the risk that you run is that the potentially winning party, I'm not even going to call it a prevailing party, the winning party in a motion may ultimately not be the prevailing party in a case, which then creates this huge inconsistency in the purpose of the Dragonetti Act, which again, I know I've repeated myself, I come back to, this is why this honorable court promulgated 1023. For this reason, it has a mechanism and a safe harbor to deal with what some party may consider to be a frivolous motion brought in bad faith.
Thank you.
Thank you, Mr. Senator. We're now going to,
Yes.
since you divided your time, need to turn to Flyback. We could ask you if you had a moment or two to make a brief argument, and then we'll commence the question.
May it please the court, my name is Robert Feeback, and I represent the verdict winner below, Rosalind Such, and the Claire Harrison defendants in the case. May it please the court, I want to go right to the other side of the coin of the question that Justice Donahue asked Mr. Titner. Even if you accept the Superior Court's view that this was a civil proceeding, there's a statutory requirement that you must prevail on all claims. Justice Mundy, when she was in the Superior Court, wrote an opinion, Clousey versus Stuck, 74 Atlantic 3rd, 242, 2013 opinion, in which she clearly enunciated that you have to win all the claims against you. In this case, Ms. Raynor and her firm were sanctioned separately from the sanctions that this case involves. She was disqualified from further proceeding in the case, and both she and her firm were fined a little under $50,000, $49,000. So she is not a prevailing party, even if you look at the case the way the Superior Court did. However, the way the Superior Court did look at this case ignored binding precedent from this court in Hart versus O'Malley, 1996 decision of this court, where the court stated that one who, as a general rule, one who was not a party to the underlying action cannot sue under Dragonetti. And there was a very narrow exception, but other than that, it's a bright line test that has stood the time and has been, except for this case, been applied in every other case.
Thank you. We're going to hear, thank you, Flyback. We're going to ask if any of the justices have questions, beginning, as I said, with Justice Mundy, whose name you just invoked.
Well, after that citation to my case, Chief, I can't ask any questions. Thanks.
Thank you, Justice Mundy.
Justice Bear.
Yeah, Counsel, I have a question. You hearkened back to the other collateral proceeding involving the letter to the hospital. What about the fact that your client won a new trial? How does that impact the question of whether there was whether the other side prevailed in this case?
Your Honor, there's no question that Rosalind Such prevailed ultimately in the case. She got it. Well, she won the first case too, but it was inadequate damages because of the issue that brought us here. But she is the ultimate prevailing party in this case, and there's no question about that when you look at it from the standpoint of the underlying medical malpractice.
Well, I guess my question is more specific. Why, and I may well be missing something, why is Ms. Radnor the prevailing party on the transaction we're talking about when it's true she got the award for contempt vacated, but it's in that same proceeding a new trial was granted, unless I'm missing something.
Your Honor, Justice Baer, let me tell you a little bit about the case that Justice Mundy decided. That was a case in which a defamation claim was brought by the plaintiff in the underlying case. The plaintiff withdrew that claim, but added 6 different allegations of claims against the party who became the plaintiff in the Dragonetti case. When the case was brought under Dragonetti, Justice Mundy said, no, you've got to win all your claims. You can't just win one claim. You have to be the prevailing party on all the claims. And that is the way all the lower courts have interpreted the Dragonetti case and the statutory requirement of prevailing party. And because in this case, Ms. Raynor and her firm were sanctioned on other contempt claims made by
All right. May I ask you, if you prevail before this court today, are you going to turn around and file a Dragonetti Act against Ms. Raynor? Are we going to review this case for the next 40 years?
Your Honor, I've never filed a Dragonetti case.
Okay,
My career, at this point in my life, I don't think I'll start.
Thanks, Chief.
Thank you, Justice Todd.
I have no questions, Chief.
Justice Donahue.
Yeah, Counsel, I'm going to try one more time. Is it not our role here to do an interpretation of a statute that uses the phrase civil proceedings? It is not a statute that uses the phrase civil action. And in that context, how do we get from the use of the phrase by the legislature of civil proceedings to your position that this requires a complaint, i.e. a civil action, in order to trigger any potential application of the Dragonetti Act?
Your Honor, since the Dragonetti Act was enacted, that has, up until this case, that has been the way in which it has been interpreted for the reasons that Mr. Tintner stated. I would also say there is no case that I could find in this Commonwealth that interpreted it the way the Superior Court did. And in fact, when you do a nationwide search of malicious prosecution, you find no case in which any court has ever held that a intra-case motion for contempt or sanctions satisfies the requirement. And in fact, the Lawson case, which is cited at the in the Messer brief, was a case in which the California court specifically criticized that as being not the way in which we should be approaching it. We should be approaching it as a prevailing party in the underlying litigation. And in the case of Rosen versus American Bank, you really had the same thing. You had an ancillary proceeding against Paul Rosen, a lawyer. And in that case, the court said, no, you can't be a Dragonetti plaintiff because you are not a party to the underlying action. In Pulaski versus Smarto, Your Honor,
Counsel, I'm aware of the case law, but the essence of what happened here is very hard to distinguish from what would occur in a quote unquote civil action. And I'll say it again. I mean, there was not only a 3-day trial, but an award of $1 million and then execution on that award. What distinguishes what happened here in reality from what happens in a civil action?
Your Honor, I would submit that it was a motion for sanctions and or contempt. It is not different than any other garden variety motion for sanctions. You would be giving standing to any lawyer or party who wins a sanction motion to then turn around and bring for Dragonetti. And I would point out that in this case, Your Honor, the Dr. Geller, who was a defendant in the case and who was responsible for 1/3 of the verdict in this case, was a respondent in the contempt proceeding. Dr. Geller could have been a plaintiff as easily as Nancy Raynor, and because there was no, in his case, he won at the trial court level. And if you expand the reach of this law that way, you're going to have case after case after case, all within the ancillary proceedings of a larger case, where the plaintiff in the ancillary proceeding Dragonetti case may be the loser in the ultimately large case, which I don't think is anticipated by the statutory requirement that you be a prevailing party.
Okay, thank you.
Thank you. Thanks to both counsel. Do you have a word or two of information before we turn to Mr.
Yes.
Thank you.
Yes, Your Honor. Thank you. In closing, I would point out that the holding in this case ignores two precedents of this court: the 1996 decision in Hart v. O'Malley, which I mentioned, and the 2002 order of this court, which suspended 8355, which would have given standing for sanctions under the Dragonetti Act. The Superior Court ignored its own bright line test in this case, and it ignored that even if you agree that a sanctions motion is a separate proceeding, the Superior Court ignored the fact that Ms. Raynor and her firm were not prevailing parties. For that reason, Your Honors, I respectfully request that the court reverse the decision of the Superior Court and affirm the trial court's dismissal of the complaint.
Thank you.
Thank you.
Mr. Haynes.
Members of the court, my uncle Cliff Haynes and I represent Nancy Raynor. Periodically, you have broken up on me in the audio portion, and I don't see any of you. But if you have difficulty hearing me, please let me know. And if I don't get an entire question that you may ask, I may ask you to repeat, not because I don't have my hearing aids in, but because you've broken up. I think Justice Donahue really has put her finger on the principal issue here, and that indeed my opponents are doing everything they can to stuff the rabbit in the hat. The question is very simple. What does the statute mean when it says civil proceedings, plural? I don't want to go into the history of the statute. I think I know it pretty well, but it's not directly relevant here, except to the extent that the statute was specifically drafted to expand the scope of a lawsuit, a claim for wrongful use of civil proceedings. Despite the argument to the contrary, there is no case in Pennsylvania that says that civil proceedings means a single civil lawsuit. Proceedings are proceedings. If this court were to look, you would see that there are roughly 3,000 cases reported that refer to contempt proceedings. This was not a motion, this was a proceeding. And as a proceeding, it falls within a clear understanding of what the statute says. And contrary to the argument of my opponents, No court has said that it is simply a lawsuit and nothing more that authorizes pursuing a Dragonetti claim. I want to talk about the public policy issue only to briefly to this extent. What happened in the trial court is an embarrassment. It is an embarrassment to the judge who oversaw the proceedings. It's an embarrassment to the lawyers who brought it. They misrepresented facts. They took liberties with the language that was offensive. And if you say, well, this, that's okay, this public policy argument that we would open the door to these kinds of lawsuits, I would respectfully suggest you're doing just the opposite. The purpose.
Thank you, Mr. Hayes. Mr. Hayes. Mr. Hayes.
Yes. I'm here.
That exhausts the, I know you can't see us, but that exhausts the time we've set aside for your opening statement. So you might want to take a few minutes to respond to any questions and that the court might have, and we'll begin those with Justice Doherty.
Counsel, as a former trial lawyer, I have a concern. Share with me that if this court finds Dragonetti under these circumstances, i.e. motion practice, what prevents the threat of a Dragonetti in a normal trial every time your adversary tries to practice motions? Or what is it? To me, it's creating a effect. If we follow through on your belief that a motion practice is Dragonetti, and secondary to that, why Dragonetti when you could have gotten relief under 1023.1?
Well, there are two prongs to that, Judge, Mr. Justice, excuse me. Number one, this is not motions practice. This is not intertrial motion practice. This is a separate civil proceeding. Yes, 1023 addresses the common motion practice that you're talking about, but 1023 didn't abrogate the Dragonetti Act. And the Dragonetti Act is there to allow for a much broader sweep than simple motion practice. I agree with you that if Dragonetti were open up to, a motion for, I don't know, a motion for the production of documents, it would be an absurdity. And none of us, I think, contemplate that that's the kind of thing. But this wasn't handled as a motion, even during the motion for new trial. It was handled as a separate proceeding and characterized as a separate proceeding. There was a claim made, there was testimony taken, there was argument by counsel. And if you look, my client is a party to that. So it's very different than the common motion practice Your Honor is talking about.
But counsel,
the facts of this
Counsel, my concern is if you say this is a separate civil proceeding, if I filed a motion to compel discovery against you, you didn't come in and follow through with the discovery by the court ordered date, and then I filed a motion for sanction, we'd have a full hearing. We'd have evidence, and there'd be a judgment. Why is that any different?
No, sir. I most respectfully disagree with that. That's not the case. That's what 1023 is intended to address. Sorry, we're talking over one another. I apologize.
No, you can answer the question.
I think we're talking over.
I think you're having a delay, sir. I apologize. It's me.
It's my fault. I saw your mouth moving and I thought you were still talking, so I apologize. It is a vastly different thing. 1023 was intended to address the simple motion situation. This is not that. This is a unique proceeding. That's what a contempt proceeding is all about. This is Mrs. Raynor was held in contempt by the court. No court is going to conclude or say that a sanction for a frivolous motion is a contemptible act. It's not. It's not an order. So it's not subject to Dragonetti.
Thank you.
Thank you, Mr. Haynes. Justice Wilkes.
Thank you, Chief Justice. Counsel, I want to further pursue that line of questioning. I don't discern in your argument any satisfactory limiting principle other than it's Dragonetti eligible when you say it is. Every member of this court was either a trial judge or trial lawyer or both who's been in countless hearings. And I don't discern any limiting principle in your argument that would carve out any of the hearings in which any of us presided or participated as not Dragonetti eligible. It certainly can't be limited to contempt proceedings. I don't discern that to be your argument. It certainly can't be something involving Ms. Raynor, obviously. It can't be something that says when a bunch of us sitting around a table feels that it's big enough. There are innumerable scenarios in which if your argument is accepted, it seems to me, that we will see Dragonetti proliferation. We certainly can't just expect that lawyers will show restraint or ask lawyers to show restraint and then walk away from it. So I'm going to ask you again to give us a clear limiting principle of what this thing encompasses other than, boy, this was a really outrageous one. This has to be Dragonetti eligible.
Well, Judge, Mr. Justice, excuse me. I'm troubled by your question, frankly, to this extent. A Dragonetti action has to conform to all of the requirements of the act. First of all, it's got to involve a party. So in a common motion, I don't see how opposing counsel could possibly be a party. Here, Mrs. Raynor was a party and the only party to the claim for contempt. Secondly, there has to be a loss. A lawyer who loses a motion to compel discovery can't prove a loss. It seems to me that it is so distinguishable from the common motion that it, and I hate to say this to you, but it's patently obvious that there's a distinction between the two. And I don't know that I can better articulate it than I already have. This court, with all due respect to my opponents, made a specific point in the Hart case to say there are exceptions. And in Hart, Justice Aplt literally describes this unique situation. So I don't see how the act transposes into the common motion. It ain't it is not a proceeding. There isn't evidence taken in a motion. There isn't a finding by the court. There isn't an order that has been violated. All of those things are necessary. You don't get to a motion, to a contempt proceeding without a violation of an order. And so common motion practice doesn't involve a violation of an order. And I suppose if some dilatory lawyer says, well, I'm not going to do what the court says, theoretically the court could try to hold that lawyer in contempt. for violating the order, that lawyer would be entitled to a hearing and a finding, and the court would have to determine that there were some meaningful damages. To me, it is inconceivable that that ever gets to the point where there's a lawsuit involved that incorporates the Dragonetti Act. I mean, I've got a client who not only was sanctioned, not only did the lawyers go after her bank accounts, she lost her job for all intents and purposes. She was the subject of ridicule in the legal community, probably as far west as Pittsburgh. I mean, this was reported throughout the country. This is so distinguishable. It's not just Ms. Raynor's case, but it's so distinguishable that it cries out to me that this particular contempt proceeding is precisely what the act is designed to cover.
Okay, Justice Mundy,
No questions.
Justice Bear.
Mr. Haynes, is there case law on whether this act should be construed broadly or narrowly?
Well, there's a great deal of case law in Pennsylvania, albeit from the federal courts. And the federal courts have consistently in Pennsylvania, mostly in the middle and western district, looked at this and said that ancillary proceedings are subject to the Dragonetti Act.
I'm having a little difficulty.
I hesitated a little bit because the restatement of tort, the law of Pennsylvania, I'm sorry, I said the restatement of torts may or may not be the law in Pennsylvania on this particular subject. You all have identified it in at least one case. It is obviously, not obviously, it's section 674. And 674 in subsection F talks about ancillary proceedings. At best, this is an ancillary proceeding.
Mr. Haynes, may I interrupt you?
Intra-trial.
Can you hear me? All right.
If I said no, what I can.
Difficulty with Mr. Haynes.
Right.
I think we've lost, if you can hear me, counsel, I don't know about Mr. Haynes. We've lost Mr. Haynes. Mr. Haynes, are you back?
I'm here. If you can hear me, I'm here.
Okay, well, let's do it this way since there's a little technical difficulty, we believe, at your end. Justice Bear is going to put his question to you again. You respond, and then we're going to conclude the argument.
Okay.
And why should we not construe this very narrowly, prohibit the lawsuit, because your client and the other lawyers, and I agree it's an appalling situation, but they're angry with each other, and as a matter of policy, we don't want you fighting in our sandbox.
Well, I'm not sure what the question is, but
the question is whether this should
let me say this
narrowly. All right.
Let me say this.
Thank you, Mr. Haynes. With that, we're going to conclude the argument, and we'll commence the final argument of the morning in 10
Argument is in the matter of Commonwealth of Pennsylvania versus Mitchell Gregory Peck Jr. Representing Mr. Peck is Brian McNeil. Representing the Commonwealth is James Zomkatovich.
Good morning. The appellant in this criminal case challenges the sufficiency of the evidence supporting his conviction of drug delivery resulting in death. He does so on the grounds that his conduct did not occur in Pennsylvania. Neil.
Good morning, Your Honors. Counsel, may it please the court. My name is Brian McNeil. I'm with the York County Public Defender's Office, and I represent the appellant, Mitchell Peck Jr. This case is simple. The parties agree that for a drug delivery resulting in death, there must be a violation of Pennsylvania's Controlled Substance, Drug, Device, and Cosmetic Act. So this case really comes down to whether there was such a violation, where the delivery in question occurred in Maryland as opposed to Pennsylvania. Due to the plain text of the Act, there simply was no violation. Section 780.113a provides a list of activities that are prohibited within the Commonwealth. One of these activities is delivery of a controlled substance, but there was no delivery within the Commonwealth. Again, the only delivery here took place in Maryland. There's just no getting around this clear limitation on what the Act does and does not prohibit. So in a drug delivery resulting in death prosecution, this provision mandates that the delivery occurred within the Commonwealth of Pennsylvania. Not Maryland, not Yemen, not some other place. Only a Pennsylvania delivery will do. The Commonwealth makes several attempts to get around this text, but none of them succeed. The Commonwealth argues principally that there's a violation of the Act, even though a conviction under the Act would have been categorically impossible. Now, this is problematic as a matter of common sense because it's hard to see how something that categorically cannot give rise to a conviction under a statute constitutes a violation of that statute. And more fundamentally, what the Commonwealth is really arguing is that there was a violation of subsection A30, which describes deliveries, but it's saying that without regard to what section A actually says. And that cannot work in this case because it's section A that contains not just that within the Commonwealth language, but it contains the prohibition itself. And so the court cannot look to subsection A30 without regard to what it says in section A. The Commonwealth also argues the jurisdictional provision of the Crimes Code overrides the Act's geographical restriction. Now, it's true section 102 says there was jurisdiction over the drug delivery resulting in death charge because one of its elements, the death of Mr. Hunt, took place in Pennsylvania. But that has nothing to do with an entirely separate geographical restriction contained in the Act. The upshot is, yes, there was jurisdiction over a drug delivery resulting in death charge, but the Commonwealth failed to prove one of its essential elements because there was no violation of the Act. That's why Mr. Peck's conviction and judgment of sentence should be vacated.
Thank you, Mr. McNeil. We're pleased to finally have a simple case. So let's start with Justice Donahue.
Good morning. I'd like to talk to you about Section 102 of the Crimes Code. And I'm really interested in your understanding of what the purpose of Section 102 is. And I'm going to call your attention to a phrase that appears in subparagraph A. And it states, except as otherwise provided in the section, it says, a person may be convicted under the laws of this Commonwealth, and then it goes on and lists certain situations. Your position is that that language means a person may be prosecuted.
That's correct, Your Honor.
But that's not what Section 102A says. It says a person may be convicted. So I know you take the position that Section 102 is a jurisdictional provision, although it's called territorial applicability. So could you reconcile that language for me, the language that says a person may be convicted, with your interpretation? Is that what it actually says, a person may be prosecuted?
Because I believe it's a jurisdictional provision, Your Honor, yes, I think it's, jurisdiction is obviously a prerequisite to any criminal prosecution. And so I think the way it says a person may be convicted, that's true, but it assumes they may be convicted if all of the elements of an offense are actually proven beyond a reasonable doubt.
But let me just interject there, because I understand your argument and I appreciate it and I almost agree with it. But I'm a little bit stymied by the language that talks about a person may be convicted, not a person may be prosecuted.
Well, obviously, I don't personally see a conflict between those two provisions. However, if there is a conflict between the two of them, then certainly in this situation, the more specific legislation, the Act, which applies directly to the conduct that we're looking at, would have to control over whatever it says as a general matter under the Crimes Code under Section 102.
Okay, thank you.
If there is a conflict, that is certainly how I would resolve it.
Okay, thank you.
Thank you, Justice Doherty.
Counsel, here's the question. The question is that DDRD falls under the crime code dealing with a homicide, yet it within that statute makes reference to the Controlled Substance Act. So if we follow the statutory construction, why wouldn't 102 control that being where the body's found?
Your Honor, I think 102 does control as far as the jurisdictional question is concerned. That's why I think there was jurisdiction over the drug delivery resulting in death charge, because Mr. Hunt's body was found in Pennsylvania. But as I've consistently argued all along in this case, that just sets the stage for a possible prosecution. If there's jurisdiction, yes, they met the prerequisite for jurisdiction to bring a prosecution. But then they brought a drug delivery resulting in death charge. And that particular charge has this language that requires a violation of the Act, which in turn requires something to have occurred in Pennsylvania in order for a violation to have occurred. So certainly if there was no jurisdiction, then the whole ball game's over and they couldn't have brought any charge at all. But here, the jurisdiction allowed them to bring some sort of charge on the basis of Mr. Hunt's death because that occurred in Pennsylvania. I think in the reply brief I said maybe they could have brought an involuntary manslaughter charge if they had wanted to do that. But the charge they brought, for whatever reason, contains very specific language that requires a violation of the Act, and the Act in turn contains very specific language that confines its prohibition to activities occurring within the Commonwealth of Pennsylvania. And we just don't have that here.
So are you sharing with us that the death of the individual goes unpunished because of a General Assembly error?
I don't think it's necessarily a General Assembly error, but to get to the first part of your question, he wouldn't necessarily have to go unpunished. As noted, they could have brought some sort of other charge, perhaps, on the basis of the death occurring in Pennsylvania. It's this particular charge that contains particular elements that are essentially unprovable in this case because of the way things panned out. Now, as far as whether someone else in another jurisdiction could have brought a charge, I don't know about that. It's certainly a possibility. But as far as whether the legislature made a mistake, I don't think they necessarily made a mistake here. I think that they used very clear language, and it's reasonable to presume they intended the effects of that language to take place. And that's especially true where the drug delivery resulting in death statute makes specific reference to the Act. So I don't think this is some crazy confluence of statutes that the General Assembly could not possibly have conceived when they drafted these two statutes. I think it's the natural consequence of very clear, definite language that places strict rules on what drug delivery resulting in death can and cannot punish.
Okay, thank you. Well argued.
Thank you, Your Honor.
Justice Wecht.
Thank you, Chief. No questions for Mr. McNeil.
Justice Mundy.
I have no questions.
Justice Bear.
You're on mute, Max.
Can you hear me?
Now.
Yes, I can, Your Honor.
Thank you, Justice Donohue. I have a giant sign in front of me that says mute, and then my mind goes.
Job.
Great, I appreciate it. Very similar to everybody else, but I I'm slow to accept your underlying premise that the 18102 is a jurisdictional statute. And it's an unusual case in that if you look at the Drug Device Cosmetic Act, and it says it has to commit within Pennsylvania, Pennsylvania becomes a defined term, maybe an ambiguous term under this unusual case. And 102 is not jurisdiction, it's territorial applicability. And it says for purposes of the Crimes Code, if you buy drugs in another state, which is what happened here, and it can be California, you're right, it can be anywhere, it can be Hawaii. If you buy drugs in another state, you come back here and you die here, that the territorial applicability of Pennsylvania would include that transaction. And it seems to me the linchpin of your case is this is a jurisdictional section, and I don't know where you get that.
Well, I think that it's a very general, it has very general applicability. And in fact, throughout the briefs, and I think even in the Superior Court, everyone's kind of referred to it and understood it as a jurisdictional statute. And I think that a lot of cases refer to it as such as well. Now, it talks about, it's in a general portion of the Crimes Code talking about when prosecution can be brought in Pennsylvania and when they can't. And so I certainly view it as a jurisdictional matter. But I'm sorry.
Why isn't the word Pennsylvania, under the admittedly unusual facts of this case, subject to construction, and the legislature construed it in the territorial applicability to include when somebody dies within our state, which certainly our legislature has an interest in, as a result of drugs bought elsewhere?
I think it does include that. I think it includes the death having occurred in Pennsylvania, because that means one of the elements of the offense occurred in Pennsylvania. But under the way the act is written, it's not the death that's relevant, it's the delivery. And it's the delivery that occurred 100% in Maryland and not at all within the Commonwealth of Pennsylvania. But just to get back to what, I'm sorry, go ahead, Your Honor.
No, you go ahead.
Just to get back to what you were saying and what Justice Donahue was saying earlier about a possible conflict between these two provisions, I just think it's very important to remember that that's a general provision that talks about when prosecutions can be brought in Pennsylvania at all. I'm sensitive to what Justice Donahue said about the language regarding may be convicted, but I just don't think that can be read in such a way that that overrides everything that each individual statute might have to say in Pennsylvania about the elements of an offense. Certainly, the fact that someone may be convicted in Pennsylvania wouldn't override a need to prove the elements of another offense, say murder. If the elements of murder are not completely proven, even if someone may be convicted of the offense, they aren't convicted of it if there's failure of proof beyond a reasonable doubt of one of the elements of the offense. And that's exactly what we have here due to the wording of the act.
Thank you. Thank you, Chief.
Thank you. Justice Todd?
Yes, counsel, it seems to me that that is your best, clearest argument that although you may be convicted, you may not be prosecuted under this particular statute because the elements weren't met, and you could be prosecuted under other statutes. So is
that's certainly our position. I'm sorry, Your Honor, I talked over you there.
That's all right. Thank you.
Thank you, Your Honor.
Thank you, Mr. McNeil. We certainly understand the argument, and we will hear from the Commonwealth.
Good morning, James Ankitovich on behalf of the York County District Attorney's Office, behalf of Commonwealth of Pennsylvania. May it please the court. The key issue in this case is application of the Drug Act preamble provision under subsection A, which precedes all of the actual prohibited violations. It states, quote, "The following acts and causing thereof within the Commonwealth are hereby prohibited." I would note that this preamble provision is not referred to in the drug delivery in the DDRD statute. The DDRD statute specifically refers to, quote, section 13A, 14, and 30 of the Act. it does not incorporate this preamble provision. If the preamble provision is an element of the face of the offense, then the legislature has excluded that preamble provision from being an element by not including it. In the alternative, if it's a question of territorial applicability, placement of the DDRD statute in Title 18 would cause the Title 18 territorial applicability section to have supremacy over the drug delivery, the Drug Act territorial applicability provision. In addition to the territorial applicability arguments, presuming that defense counsel's argument was entirely correct, this particular case contains unique factual elements. In this case, the actual transfer did occur in Maryland. However, prior to the victim consuming the drugs, he continued to receive ongoing tech support from the defendant, who texted him how to use the drugs. The victim didn't even understand how to use the type of heroin he was sold. He needed to contact the seller, and once he was told how to sell it, or how to use it, used it, and then expressed how strong it was, how uniquely strong it was. The details of that element of the text message transcript are included in my brief.
Thank you. Justice Donahue, do you have any questions?
Yeah, yes, I do. Counsel, back to section 102, which your opposing counsel and other courts have interpreted to be a jurisdictional provision. I'm going to call your attention to subsection 6 of section 102, or subsection 6. And this particular subsection applies to a Pennsylvania statute that expressly prohibits conduct that occurs outside of the Commonwealth. And so we have a provision in the Crimes Code in section 102 where the General Assembly anticipated that there may be a statute that is expressly applicable to conduct that occurs outside of Pennsylvania. And the statute goes on in subsection 6 to require the court to do a balancing of interests to determine whether or not jurisdiction should be exercised under that particular provision. And so I find it hard to grapple with your position that this statute overrides another provision of Pennsylvania law that requires conduct that actually occurs in the Commonwealth of Pennsylvania. And could you help me with that? Because subsection 6 would seem to be what you would need to rely on had the General Assembly written that it was a violation of law to sell drugs anywhere. In which case, the trial court would have to say, what business is it of Pennsylvania to control the sale of drugs anywhere? So can you help me with that?
Yes, Your Honor. In this particular case, the delivery of the drugs is simply an element that occurred outside of Pennsylvania. The main inquiry is regarding the homicide aspect, and that's why we believe that this falls more under General Rule subsection 1 and the later referred section 6.
Yeah, I understand that, but you're not answering my question about the General Assembly's anticipation that they might write a statute that attempted to prohibit conduct that occurred somewhere else, and then made provision for what a trial court's supposed to do in determining whether or not that case could continue within that particular Court of Common Pleas. I mean, there's no question. I mean, I think you admit that the Drug Control Act that we have at issue here specifically requires conduct within the Commonwealth. I mean, they could have said in this drug delivery resulting in death, they could have not referred to that particular Pennsylvania statute, and they could have said any drug delivery that results in death is this first-degree felony. But that's not what they did.
Your Honor, in regards to the element that the drug act, the delivery occur in the Commonwealth, that's not entirely an accurate representation of what the Drug Delivery Device Cosmetic Act actually states. It says the following acts within the Commonwealth and the causing thereof within the Commonwealth. If the legislature had placed the DDRD statute into Title 35, the Drug Act, let's say they placed it at the end, I believe subsection 40 is still open. Let's say they place it in subsection 40. The fact that the death occurred in Pennsylvania, if the delivery still happened in Maryland and it was under this test of acts and the causing thereof within the Commonwealth, the causing of the death within the Commonwealth would have satisfied this statute even if it was entirely under the Drug Act.
Yeah, but counsel, the Controlled Substances Act doesn't deal with death. The Controlled Substances Act, in the section that you're referring to, refers to the following acts, let's just say the delivery of drugs and the causing thereof within the Commonwealth, which would be the delivery of drugs within the Commonwealth. The statute that is one of the predicates for the prosecution under the drug delivery resulting in death, this particular part of it only deals with the delivery of drugs.
That's correct, Your Honor. And when the trial court did its evaluation as to whether or not jurisdiction existed, it evaluated the drug delivery resulting in death statute as a whole and focused on the fact that the question of whether an element of the offense did occur in Pennsylvania. The fact that the death, and it's basically uncontroverted that the death occurred in Pennsylvania, the death being the more serious aspect of this offense.
Yeah, but you need, counsel, you need both parts of the drug delivery resulting in death statute to get yourself a conviction. And the first is a violation of the Controlled Substances Act, which is that which requires it to occur in the Commonwealth.
Your Honor, as the statute refers to the Controlled Substances Act, the drug delivery resulting in death statute does not incorporate the requirement that the delivery occur in Pennsylvania. That is excluded from the drug delivery resulting in death statute.
No, it does not, counsel. I mean, unless I'm missing something, the drug delivery resulting in death requires a violation of the Controlled Substances Act, my shorthand. It requires a violation of that Controlled Substances Act.
Yes, Your Honor. Well, it requires a violation of that provision of the Controlled Substances Act. To that end, the Commonwealth would refer to its brief Commonwealth versus Gerald and the federal cases Pugh v. Weems. A violation is not synonymous with a conviction and does not require even the ability to obtain a conviction. In Gerald, a defendant was charged with possession of contraband in a prison or possessing a small amount of marijuana. However, the contraband statute does not include small amount of marijuana as an offense to which that would invoke the contraband provision. Generally, possession of a controlled substance does. Now, when someone possesses a small amount of marijuana, in theory, they could also violate the possession of controlled substance statute. However, under Pennsylvania case law, if you violate small amount, you're not to be convicted of the higher offense of possession of controlled substance. Therefore, while it under Gary, while it's impossible for an individual possessing a small amount of marijuana to be convicted of simple possession under Section 14 of the Drug Act, it's sufficient for this type of situation that the violation element is met. Not that a conviction can be obtained, but that a violation.
Thank you, counsel. We're going to move on because some of the other justices may have questions. We'll turn to Justice Doherty.
Again, my question, good afternoon, Commonwealth. My question is a follow-up of Justice Donohue's. A violation of the Controlled Substance Act is an essential element in the drug delivery resulting in death. The violation of a Controlled Substance Act is geographically restricted to the Commonwealth. How do you justify not having a violation within the confines of the geographical Commonwealth to support your conviction for drug delivery resulting in death?
Yes, Your Honor. The way that this particular statute's read, as I've mentioned previously, this statute does not incorporate the territorial applicability provision of the Drug Act, and therefore it should default to the territorial applicability position of Title 18. However, to get more directly to answer this question, when an individual, let's say that applying the same statute, let's say an online pharmacy in another state or a distributor delivers a amount of controlled substance to a pharmacy just across the line in Maryland. Let's say that they've unknowingly purchased a bulk of contraband controlled substance, which falls under Act 30. A person in Pennsylvania drives across the border to their nearest pharmacy in Maryland, buys the drugs that they believe that they are able to get with a prescription, comes home, and taking this counterfeit controlled substance, dies. It is in the interest of the Commonwealth to be able to go after the individual that caused this controlled substance, this counterfeit controlled substance in this case, still under the same subsection, Section 30 of the Drug Delivery Device Cosmetic Act, to be subject to prosecution for causing the death.
Counsel, just hypothetically speaking, the violation of Section 13A, 14, or 30, that would include possession, correct, if I'm not mistaken?
Simple possession under 14, yes.
Now, my understanding based upon these facts is that heroin was found on the table of the nightstand when they found the body. Correct?
Yes, sir.
So had you charged him with possession at that time as opposed to delivery for which was discharged, would that not have been a stronger case for the Commonwealth because, in fact, he could have been convicted of violation of possession despite the fact that he's dead, as opposed to delivery? When you say violation, where is the violation within the Controlled Substance Act within your fact pattern?
Your Honor, the violation is the delivery of the controlled substance and causing the delivery to occur within Pennsylvania. Now, in this case, the victim he purchased it at the defendant's house, which was just across the line in Maryland, then returned home. And in this particular case, we have the bonus information of the victim having to contact the defendant to obtain the instructions on how to use this type of heroin. Basically, this victim had only used the powdered heroin and snorted it. This type of heroin.
Counsel, we're very familiar with the facts, as you can tell. So we're trying to get to the heart of the matter, and I'm going to ask Justice Wecht if he has any questions.
Thank you, Chief Justice. Good morning, counsel. I have questions about several of your arguments. I'll try to confine them to a couple. Is your argument that even though the act of delivery occurred in Maryland, because there were text messages between a Pennsylvanian and a Marylander, that it qualifies somehow for the statute?
That's one argument to be made, Your Honor. That's not my primary argument, but that is one argument that can be made.
So then you're saying that the reach of this statute will encompass anything occurring anywhere outside of Pennsylvania, so long as a Pennsylvanian is texting with somebody outside of our borders?
If that texting results in the death of the Pennsylvanian within the state of the Commonwealth of Pennsylvania, arguably, yes.
Well, shouldn't you go to the General Assembly to ask them to rewrite the statute instead of coming to us?
If I had done so, Your Honor, I believe they would have had to write the statute the way it's currently written.
All right. And with regard to the way it's currently written, you want us to read subsections 14 and 30 of Section 780.113 without subsection A. How do we make sense of a clause without its beginning?
Your Honor, because the legislature specifically did not include that beginning section. The following acts and the causing thereof with the Commonwealth are thereby prohibited. That particular language is simply not included.
Well, you don't, in the drug delivery statute, sir, after the 13, you see the subsection A, don't you?
Yes. Yes, Your Honor.
So given that you see the subsection A there, isn't it nonsensical carve out 14 and 30 without their call-out clause in A.
No, Your Honor. In fact, I would argue it's necessary. The way that this particular statute is written, it specifically excludes the preamble provision. The preamble provision is not an element of the offense. It's a territorial applicability. It's the equivalent of Section 102 of Title 18. Only it applies to the Drug Act, because Section 102, only applying to Title 18, would not have applied to the Drug Act on its own.
No further questions.
Okay, well, we're almost out of time, but and we have, well, anyhow, I'm going to ask Justice Monday if she has any questions before we conclude.
No questions, thank you.
Okay, we're down to 2 minutes. Justice Bear,
No questions. Thank you, Chief.
Justice Todd.
Yes, Chief, just one quick question for the Commonwealth. This is undoubtedly a tragic case, and I agree with you completely that it would be in the interest of the Commonwealth to be able to prosecute this case. But the problem is, prosecuting this case in the manner that it was charged does not seem to me to be possible under this statute. And I'll just give you one last chance to tell me I'm wrong.
Your Honor, this particular statute simply doesn't include the territorial applicability provisions of the Drug Delivery Device and Cosmetic Act. If you actually apply the statutes that are set forth in Title 18 of the drug delivery resulting in death statute, that a delivery occurred, the delivery was a controlled substance, and that a death occurred, that the Commonwealth has met its burden, and that the element of death having occurred in Pennsylvania satisfies the territorial applicability provision of Section 102. Now, if the other sections were expanded, there's arguments that for the defendant's own ratification, his continuing service of the transaction in Pennsylvania when the victim was at his house, that could also be argued to satisfy this in this particular case. But generally speaking, Your Honor, I believe that the territorial applicability provision of 102, Title 18, should have primacy for any offense in Title 18.
Thank you.
Thank you. Thanks to both counsel, and that'll conclude this argument. The court will recess until 12:40.
Court is in recess until 12:40.